Welcome to this session of EJIL Live, which is coming to you from Madrid. And I want to thank the Instituto de Empresa, which allowed us to record this EJIL Live on their premises. And I have with me Dr Veronika Fikfak, who's a lecturer at Cambridge, and whose article, which we are featuring today, Changing State Behaviour, Damages Before the European Court of Human Rights, was part of our Young Scholars Initiative, and we thought it was just splendid. You will find it on open access on the website, and it's a great pleasure to have you with us today.
Thank you for having me.
Now, grant me, we publish endlessly on the European Convention on Human Rights, but I would say that 80% or even maybe 90% of what we publish tends to take the shape of reading, critically or otherwise, some decision or series of decisions of the European Court of Human Rights and analyzing them from a hermeneutic point of view, from a value point of view, but really relating to their content. And we are much less concentrated in the literature, and there's a much bigger, in my view, knowledge gap in two respects. One, the record of compliance with decisions of the European Court on Human Rights, and even less knowledge do we have, less research is performed, and in this sense, and not only in this sense, this is a pioneering and breakthrough article on the practice of awarding damages. When do they award damages? What is the quantum of damages? What are the principles in awarding damages? And what effect, if any, do the damages have on state compliance? So that's the theme of this tremendously interesting and important article. And I'm going to ask you, Dr. Fikfak, just to introduce what drove you to do it, what is the premise, and lead us towards your main conclusions.
Mm-hmm. So I used to work at the European Court of Human Rights, and when you work for these institutions, there's always something that happens that don't know how it happens. So there's a mystery to certain things. And one of the things that always fascinated me at the court is how they came up with the number. Because the court doesn't really, in the decisions, explain how they come up with the number.
You're talking about the number of the damages awarded.
The number of damages, specifically non-pecuniary damages. And if you look at any decision, I think as scholars or as teachers, we sort of stop at, is there a violation or is the case admissible? But if you keep on going and reading, you notice that there's this part of the judgment where the applicant asks for millions and millions of euros in damages. The government contests that, and then the court says, based on an equitable basis, we award, let's say, 10,000 euros. And there's no reasoning provided, there's no explanation on how they came up with that number. And so for the last 3 years, what I've been doing on a grant and with a team of people is we've been trying to code 12,000 decisions of the European Court of Human Rights to understand which variables of the case, which elements relating to the victim, relating to the state, relating to what happened, might be influencing the number that they come up with.
The actual quantum of damages.
The actual quantum. And then when I got
and as you said, just to underline this, it's particularly interesting when the damage is non-pecuniary.
Absolutely.
So you don't have actually measured, I suffered 20,000 euro damages, so I want that back. It's for non-pecuniary damages. What is the quantum of damages awarded?
Exactly. So these are the damages that are for pain and suffering. So how do you quantify that? And now what we know, and we know this from textbooks, we know from discussions with people, that there are scales inside the court. So kind of a menu of how much pain and suffering for each article is worth. But they haven't been published, and they're unlikely to ever be published. And so for me, what I've been trying to do with the team for the last 3 years is I've been trying to work backwards to figure out how they come up with that number. And so that's what the project has been. And there have been some really fascinating results. The first one is that the victim appears to be completely irrelevant to the calculation of damages. So whether or not you're in a wheelchair, in poor conditions, in somewhere, let's say Greece, that makes no difference compared to somebody who's young. And those kind of things I found really intriguing, because we perceive the court as really focusing on the victim, on the individual, but that is not coming through in relation to damages. And so when I got the different results, I actually went to the court and spoke to judges, because I needed to make sense of what I was seeing empirically. And putting those different methodologically sort of approaches together, both the quantitative and then the interviews, I really got a different story of what the court was doing in relation to damages.
Could you just tell us, we're not going to spill all the beans, because we really want to encourage our readers to go into the article and read chapter and verse. But could you start off by just giving us, with a few examples, what's the general scale of damages? Somebody loses a hand, so to speak.
So what's really fascinating is that if you go to a domestic court, you sort of know what you would get for a hand. Well, that doesn't appear to be the case when you go in front of the ECtHR. But let's say for torture, we know that torture is between 18,000 and 20,000 euros. So one event of torture that's been qualified as torture is going to get you that. Degrading treatment, it's about 3,500 euros.
And how do they define the event? Let's say somebody is in one of these places where the torture takes place, and he or she are tortured for 16 consecutive days. Is that 16 events, or is it one event?
It seems to be one event. It seems to be one event. But the duration does appear to be one of the elements that is affecting damages in certain cases.
So a cynical member of the security forces can say, okay, let's torture, this will cost us 18,000 euro.
Absolutely. So one of the things I'm seeing from the data, and that's where it got really intriguing, was that countries coming in front of the court know how much a certain behavior is going to cost. And we see in certain countries that so for example, Russia, and I talk about this in the project in the paper. Russia has a line in its budget, in its normal yearly budget, that is dedicated to paying compensation in front of the European Court of Human Rights. Now, that hasn't been used to pay off UCOS. It's being used to pay off Article 2 and Article 3 cases. And that line in the budget has gone from 7 million in 2010 to about 10, I think, in 2016. So there's been an increase in how much is planned to being paid for compensation for ECtHR cases. And what I find troubling, I'm not saying that Russia is planning to torture people, but that there is an element of you can anticipate how much it's going to cost you. And for a country, 10,000, 20,000, it really isn't that much.
Yeah, my economoid friends would say they're just applying the theory of the efficient breach.
Mm-hmm. Yes, so they do a sort of a cost-benefit analysis, but I think what's really interesting and what the paper sort of tries to touch on is that there's really almost no cost to doing this because the numbers are so low.
So if there is any cost, it will mostly be the naming and shaming rather than coughing up.
Yes. But the naming and shaming, there have been studies that have shown that doesn't really work when it comes to torture. It worked in relation to political rights, but not really when it comes to torture. It seems that countries that are used to naming and shaming are quite happy to keep on torturing. That the political benefit of doing that appears to be sort of, kind of get you further than changing your behavior.
I expect that many of the readers of your article will have the same reaction that I and many others had in the junior faculty forum when you presented the original version of this paper, of a certain kind of shock. That because I had never focused on damages, so at my age I have no problem in admitting to my ignorance, and I just thought to myself, wow, they're getting on so cheaply for this thing. So when you had these interviews with the judges, what was their reaction to that?
So the first question I sort of asked judges was, how do you perceive Article 41, which is the just satisfaction article? What is it aiming to do? And the answer was consistently, it's an article that's intended to pay the victim for their pain and suffering, but only in a symbolic way. And so through interviews, what became very clear is that judges are focused on the individual, and this is what they're saying, right? On the individual and on giving them a symbolic token of what they've gone through. But when you look empirically through, is the victim important? The answer is no. Then you go on and look at, so what is important? And it appears to be only the state. It's who the state is. Is it a poor state or a rich state? And then how often have they violated a specific article? And what's been really interesting is that the more you do something in certain contexts, the less you pay. And so this focus on the state is completely inconsistent with what the judges are saying in interviews, that it's really all about the victim.
Where did they come up with the notion that it has to be only symbolic compensation?
So there's this idea in the court that the European Court of Human Rights is not there to monetize human rights, to commodify them, to translate them into money. There seems to be a real focus on, we're here to interpret a convention, we're here to expand rights protection, but money is secondary.
But I mean, as you yourself were saying, and as comes out very nicely in the article, the money has a double role. It is compensation for violations of which people suffered, and it's evocative that you bring up torture because but there's also a compliance element. It's meant to be, and they're not concerned that by awarding derisory damages, if I may say so, they are reducing the compliance pool of their decisions. So are they worried that states will not pay up?
Yes, but compliance, I mean, what's really interesting is if you go through the economics literature and the behavioral economics literature, if you're going to encourage states to change their behavior in the long term, you need to make it pricey, you need to make it unpredictable, and you need to make it retributive. And so that's what one would rationally expect the court to do. But when you speak to judges, compliance is very much on their mind. They're very concerned about, is this judgment going to get implemented? So not only is the person going to get paid, but in the long run, is the systemic problem within this judgment going to get fixed? And so you would expect them to do the sort of rational thing of either imposing punitive damages or maybe not phrasing it in those languages, but really imposing a high value. But they seem to be, in certain contexts, reducing the number to help states implement the decision. So it's going the other way. It's completely counterintuitive.
And what's your evaluation of that?
So I think sometimes it happens. So judges have said that they feel that they need to help states. So in a way, you've got the court thinking of its own role in a different way as an institution. That when you become focused on compliance, you're really there to guide states, to help states. So we've moved from the victim really to the state focus. The other thing is, I think the court is really overburdened. Like the workload is really tangible. And so in that context, what the court is trying to do is really get rid of cases. And it's trying to get rid of cases by making it easier for countries like Ukraine, for example, who's fighting a war, to comply. And so they make it cheaper.
Do you see any prospect of the court rethinking this issue of quantum of damages?
So I think the judges are in a real sort of dilemma. I mean, I know at the moment that there's a review of their approach, which is about 12 years old. There's a review of the scales, but they're in a real dilemma about what to do. Do they adopt punitive damages or something like punitive damages where they would be the first court to do so, in a way, a human rights court? Or do they keep on doing what they've been doing? And I think, there's also, you've got the element of court versus registry, how things have worked for a long time, how do you change things? So you've got the institutional aspects that are making, I think, a change very difficult.
Is there a normative recommendation in your article?
I think so. One of the conclusions I come to is that the Cyprus-Turkey case, which imposed 30 million and 60 million, might actually have worked, or might actually have nudged Turkey into doing something about its 10-year, 15-year violations. And so perhaps there is an argument there that money sometimes, even if it doesn't get paid to victims, it might persuade the state to change their behavior. And so perhaps we shouldn't be neglecting money completely, but we should be rethinking how we use it.
Yet there is a margin when we say punitive damages, and as somebody living and working in the United States, we talk millions, but there's something in between. I mean, from a point of view of the state, there's not a huge difference, even a poor state. There's not a huge difference between 18,000 and 100,000. From the point of view of the victim, getting 100,000 euro for having been tortured is not enriching a person, really. Yes. And yet it's almost insulting to be tortured and saying, well, we monetize this at 12 to 18,000 euro.
Yeah.
So somehow there seems to be a disconnect there between whatever their dilemma is, but their perception of reality.
I think the really big disconnect is between the pecuniary damages, which go into millions, and the non-pecuniary, which are so small that it's almost impressive. And I think my problem is really that this case law is having an effect on the African Commission on Human Rights and other courts. We are seeing it in the UK, where domestic courts are lowering damages because people would get less at the Strasbourg level. So there's an impact that's, occurring that I don't think people are aware of.
We've also seen this in some of the normative decisions, the non-damages decision of the court, where in theory the court in Strasbourg is meant to be the safety net, the standard below which you do not go, but with an open and expressed invitation for states to have, quote, higher standards. But in reality it's setting a benchmark, and what you say suggests that states say, well, if Strasbourg only awards 18,000 for torture, why should we award more?
Yeah, exactly.
Are they aware of that effect of their decisions?
I think I think for a long time there's been very little written on damages, and so I've met with them. I've spoken to them, and I think they've been really fascinated actually by the results that I've seen, and I've gotten really good feedback that they actually want to know what I discover going forward, and so that dialogue I think is important, and they seem very open. So perhaps and I think they've looked at some of the results with a worrying face. So I think that's reassuring. Now, what can be done? I don't know institutionally how long that would take.
The article that you are publishing with us is just one segment of the research you've been conducting.
Yeah.
Just tell us in 2 or 3 words, what are the other segments? What else are we to expect from your pen, or from your keyboard, I should say?
So, I'm really taking this now onto a sort of a 5-year project where I'm trying to see when these remedies have worked. So in interviews, what judges have said is that they're concerned about compliance. And I want to see, is there really something there? Should they be concerned about compliance and implementation and internalization? Or are those completely disconnected from the remedies that are imposed? So I'm looking at nudging, I'm looking at shaming, I'm looking at all of those different things through the case law.
We often wonder, and I mean the collective, we academics, we wonder what impact our articles might have. And I don't just mean impacts in generating a lot of footnotes which you can put in your tenure review or promotion review, but what impact on the actors which we are analyzing and describing. But I have a feeling that this piece of work and this project, once published, there's a likelihood that it actually will generate quite a lot of reaction. The results, for those who are not really focused on this field, border on the shocking in some way. The policies behind them don't always seem persuasive. As you hinted, and it's more elaborate in the piece, there's a lot of inertia going on, there's a lot of path dependence that explain what's going on. So from where I sit as the editor of EJIL, I have a feeling this is one article that will actually resonate and produce results. Are you optimistic in that respect?
I mean, I hope so. I mean, I've been really blessed by the feedback I've received, from different people that I've presented this to, but really from the judges. I didn't expect such reception, such welcoming, in a way, the opening of doors. And I've been very surprised by that and very, very happy. And I think judges have, what they've told me in interviews is that for them, damages are the last thing on their mind because they need to fight through admissibility, through the violation, through the et cetera, et cetera. And then Article 41 comes at the very end. And so perhaps what I'm hoping our conversations have done, that they've slightly underlined that actually damages, that there are certain problems there that we should be rethinking.
As somebody who's writing a cookbook, the chapter on desserts is very important. So I think that they might be mistaken in consigning it as, just like a footnote at the end. And although you write in a very serene and gentle way, there's quite a bit of naming and shaming here. So that itself might have some impact. Thank you very much, Dr. Fikfak, and I invite our readers to read the article. Thank you all.
Thank you.